Thank you everyone for joining us for our Legal Docs 101 session. So I'd like to introduce you to our new speakers from Fasken. So our first is Chris Wolfenberg. Chris is a leading business lawyer in Calgary focused on public and private corporate and securities transactions in the energy, mining, and technology industries. And we have Chris Buckman, who is one of our executive business advisors as well. Chris also acts as one of the 3 entrepreneurs in residence at Fasken. He provides executive business advice, coaching, and mentoring to CEOs and executive teams of technology companies. The engagements that he oversees for Fasken involve providing advice on go-to-market strategies, financial models, executive team recruiting, financing strategies, venture capital, and conventional financing options. So with that, I will let you two take it from there. I am going to mute everyone if you can unmute yourselves now.
Perfect. Thanks, Dana. Mr. Wolfenberg, I'll turn it over to you for an intro.
Sure. Before we jump into the actual subject matter, I think I just want to explain why you're associated with Fasken and how that has benefited our clients, but also you know, your expertise has lent itself to Alberta Innovates as well, and the real reason we're here today. The last time we were here, there was a couch due to COVID. We got rid of the couch, so there's some good spacing between us. We still work closely together, and you know, since the last time we did a session like this, we've had a couple of successes. So in terms of coaching, and this is for everybody's benefit. You know, Chris was instrumental in really walking through one of our medtech clients through a private equity raise. The money came from Europe, and so there were some interesting issues that we had to deal with there. And Chris was great with you know, coaching the executive team along the way and kind of navigating the path with the investor. So you know, that's kind of the value add, and really speaks more to your experience than any kind of introduction, but always nice to talk about a win.
And just to be clear, I'm not a lawyer. I do not pretend to practice law, but it's been a great, fantastic relationship with Fasken and having that opportunity to work with startups and some of their current clients. So today, the format today, really, I'm gonna let Chris do most of the speaking because he is a lawyer and very experienced in this space. So what we'd like to do is, for any questions, if you guys can post them on the chat, and we'll do our best as we go through here today to answer a lot of those. And then afterwards, I'm very open to receiving other questions, you know, throughout the next couple of days as well. So Dana, I'll post my contact information there as well, and look forward to following up with a lot of you. So Chris, I'll turn it over to you.
Well, I do pretend to be a lawyer. I'm a lawyer, but really prefer to provide practical, strategic advice, especially in the startup world. And so what we're going to run through today are kind of the top 10 legal documents that you should have right out of the gate. We're going to talk about efficiency and certainty. So EC, those two things are critical to any startup. So as you're running off with your business idea, maybe working on some intellectual property that needs to be protected, the biggest thing that you usually forget about until it's too late is to lock all of those things down. So your intellectual property, but also your corporate structure and your corporate form that you don't spend a lot of time thinking about. And one of the best ways, and this is not on our top 10 list, but one of the best ways to deal with that problem is to solve it quickly. Most firms, including ours, have loss leader programs where you can basically buy a suite of documents, as well as some basic legal advice on how to proceed, how to structure your company, and how to deal with some of the kind of basic issues that come up for startups all the time. Those startup programs, they all have different names, but they're all basically the same. The pricing will vary, and so you need to be conscious of that. I think, you know, Chris, one of the questions you had in the can ahead of this session is how do you pick your lawyer? And my answer was looks. The reason for that is, and I'm probably not the best sales guy, but you know, all of these programs that all of the firms have are fairly standard, which is a good thing. The paper will differ from firm to firm, and so you may find some minor variation. It's not all about cost. It's actually about the relationship. Do you trust the lawyer? Can you work with them? Not are they good looking or bad looking, but can you actually trust them and work with them? So you should interview a couple of different firms, make sure that you're comfortable and that you get everything you need out of those packages. They are relatively low cost. Even if you think, our package is $2,500 out of the box, even if you think you can't afford that, it's money well spent. It's a very small insurance policy against some of the huge pitfalls that you could run into in a year, 5 years, 10 years as you look to exit or just continuing to grow your business. So the real purpose of today is to make sure that those legal documents that you've got will provide you a solid foundation for moving forward in your business. So the first one really, and this contemplates, from incorporation to your seed round, nothing further. There are other documents and other legal questions that will arise. Really today, we're going to focus on the formation of your company and through to building out your advisory board, getting your compensation packages in place, and not much more than that. So really just the foundation. We're not putting any walls up today, just pouring cement. So the very first document that you should encounter as you go to incorporate your company, and we're only going to talk about companies today, we're not talking about limited partnerships or other investment structures, is your articles and your bylaws. These are important, but really almost as standard as you can get. You want to make sure that your share structure is correct. So at the very least, and sometimes at the very most, you want one class of common shares. I have seen startups where for various tax reasons, they get some advice from an accountant and they have, I think I've seen up to 10 classes of common shares. Ridiculous. You only need one. You only want one because when you're talking about shares, you're really talking about governance and control. And most founders are really concerned about dilution and really concerned about maintaining control of their baby, making sure that they can control the outcome of a shareholder vote, have the ability to elect directors. And so in that vein, there should be nothing fancy about your common shares. Each share gets a vote and that's it. Nothing fancy at all. Not in terms of classes of shares, not in terms of rights, plain Jane, plain John Doe, nothing fancy. You can have, if you really want, to create a class of preferred shares issuable in series without attributing any rights or designating any kind of special characteristics to those preferred shares at all. So you can create them, and that may become useful to you later, especially for taking on VCs, investments, or private equity investments. Those types of investors will typically, either through a shareholder agreement or preferred share terms, require certain rights. And so if you want to, you can create that class of preferred share now, but you don't have to. You, when negotiating with those potential investors, will come to understand what rights they are going to demand and then create the proper class of shares with that particular, those particular rights attributable to them down the road. So that's really it for your articles. You need to think about how many directors you want, what your board of directors is going to look like, where they're going to come from, what kind of technical attributes you want some of your directors to have. And we talked a little bit about this last time, Chris. Your board should be helpful to you in the business sense, in terms of raising money, in terms of technical sense, finance, maybe somebody with an accounting background, maybe somebody with a legal background, maybe somebody with a banking background. Depends on what kind of business you're going to be in. So think about that, but really for purposes of filing your articles, you want to think about the number of directors. You should have an odd number, not an even number of directors, because if there's ever a tie vote, you need to break that tie. The only way to do that is for either the chairperson to have a casting vote or for there to be an odd number of directors. On bylaws, again, very simple, nothing fancy, off the shelf. But we should talk for a minute about incorporation itself. You can buy the kit and file your, articles of incorporation at any registry in Alberta. I don't recommend you do that because the off-the-shelf articles that you get generally aren't sufficient and generally are a good signal to an investor that you're not terribly sophisticated, you haven't done this before, and you're not willing to actually seek out advice on how to proceed in business. So unless you've done it a million times, I don't recommend that you just go down to AMA and file your articles of incorporation. You can do that. The cost is about the same, but better to have the right articles and the right bylaws right out of the gate. On your bylaws, the only thing you want to make sure of, and we've kind of renewed the bylaws of most of our clients over the course of the last 5 or 10 years, is that you want to make sure that you can have virtual meetings, because the standard bylaws will say meetings of the board or meetings of shareholders have to take place in Alberta. That's kind of old school. You want to make sure that you can have virtual meetings. You want to make sure that you can have virtual shareholder meetings, and so that you're not actually having to go to court in the event of a contested shareholder meeting to get permission to hold a virtual meeting, which a lot of folks had to do about this time a year ago, and their bylaws didn't allow for it. The act didn't allow for it. So you want to make sure that your bylaws are as modern as they can be. Any questions there, Chris?
No,
Okay.
nothing yet.
So file your articles and bylaws. You've incorporated your new company. Generally speaking, your lawyer can do that for you. You can do that as the sole incorporator. You should have a good idea of who your directors are going to be. There are residency requirements. So if you're bringing on Americans or others, you need to make sure that if you're incorporating in Alberta or under federal legislation, you meet the residency requirements. So pay some attention to that. There are solutions to that. And then you want to think about doing your founders round. And generally what I suggest, unless you have money already lined up, is that you think about what value has been created to date. So if you've just got an idea and you're incorporating the company, you can contribute that idea as consideration for the issuance of your founder stock. And the best way to do that, if the idea is physical in any way, you've got a prototype, or there's intellectual property by way of an asset rollover agreement or an intellectual property assignment agreement. So those two types of agreements are your first step to issuing shares. And when you issue those shares, it should be for nominal value, because the company doesn't actually have any assets yet. You haven't raised any money. You haven't really paid anything for the first share that gets issued. And you want to contribute those assets at a low cost so that the basis of your shares is as low as possible. When you're issuing founder stock, and we've just gone through the structuring for a new fintech client, you need to stage and sequence the contribution of hard assets and intellectual assets in a way that makes sense. So we held off on incorporating for a very long time until we knew what that structure was. We now know what that structure is. We're issuing the founder stock, then the intellectual property is going to be contributed, and that'll be for value, a much higher value than the nominal consideration you're issuing the shares for. That then gives you a lift, and now we're going to go out and raise a seed round at a higher valuation. So you need to be thinking about what the value of your contribution is. Not much value on incorporation. Once you've contributed some intellectual or physical assets, there's a value lift. And you also need to give some consideration and thought to when you're going to be issuing compensation securities. So either stock options or performance warrants, and we'll talk about those in a little bit. You should think about who's going to get founder stock. Is that just you? Is that your team? who is on your team, who's been around, who's pulling their weight, who's not pulling their weight. How do you pull stock back if your founding team isn't pulling their weight? Because generally, folks, when you first start, have a day job, they're not independently wealthy, and the company doesn't have any money to pay them. Which is why, Chris, you asked the question, like, on your top 10 list here, I don't see employment agreements. Well, you don't have any money to pay people. They don't have jobs. You're really paying them in sweat equity until such time as you've raised a little bit of money and you can actually pay people enough so they can pay their rent or pay their mortgage and make a go of it. And that's why I didn't include employment agreements. Once you've raised your seed round and you got some walking around money, then you can talk about those things. We're not quite getting that far today. So your asset rollover agreement, there is a way, if you have hard assets, to not pay a gain on that. It's called the Section 85 rollover. So you need to be always thinking about what the tax implications of what you're doing are. Same thing for your intellectual property assignment agreements. If you're exchanging a thing or an idea for stock, generally you can defer the tax liability on that. There may be some forms to fill out and file with CRA, but and I'm coming at this at a very high level. So you really want to contribute those assets or that intellectual property that has value, and that's going to set really the basis for your pricing on your stock. How do you pull that back? Let's say you've got a great idea, and I know this happens all the time, Chris. You've got a great idea. We're starting a company, and I say, look, I'm going to contribute some time and effort. I'm going to get my stock for sweat equity. You're going to contribute the idea, and so we're going to issue you some stock in exchange for that. You're going to sign an asset rollover agreement. You're going to contribute that. We're going to defer the tax on it. You've got your founder stock. I've got my founder stock. And then you disappear. We're not friends anymore, and you're just not pulling your weight. How do I get that stock back? You might ask. The best tool that I have found and that I really like is a reverse vesting agreement. So we're both bound to continue to contribute to the company's success, because yes, we've issued ourselves some stock, but the company's going to take it back if we're not pulling our weight. And a reverse vesting agreement allows you to get the benefit of the founder stock pricing, but you lose your stock if over time you haven't hit certain milestones or you're not pulling your weight. And so you can tie it to specific milestones, or you can tie it to a board decision to pull that stock back. Otherwise, you're stuck with the situation, and I've run into this, where guys have a big whack of founders shares, and they're just either not hitting the mark or not pulling their weight. And you can either have a really bad fight with those guys to try and take that stock back, or you can dilute them down by issuing additional shares. But the easiest way is to agree to it up front that if you're not pulling your weight and you don't hit certain targets, you lose stock.
Chris, we have a question from one of the people attending. So Brent is wondering, is this the same as a buy-sell agreement?
Yeah, good question. It's not. And the reason it's not is that the company isn't buying or selling the stock back. You don't get paid for it, you just lose it. And that's the agreement you strike with the reverse vesting agreement is, I'm getting this cheap stock, but I still have to contribute. And if I'm not doing my job, it just disappears. It's in the same way options will vest as you hit certain either time or productivity milestones. On the reverse vesting agreement, it's really your lack of contribution that will make those shares disappear. They don't get bought or sold, they just get canceled when they get returned to Treasury. And so the other founders will benefit because they will own a higher percentage of stock in the company because the other founder has lost their stock. They just disappear off the balance sheet. So not a buy-sell agreement. You could do it that way as well, but those are harder to implement. And you can have shareholder agreements that account for that. Sometimes though, it's hard to find the money to buy somebody out. And so easier to say, you're just going to lose your cheap stock because you're not pulling your weight. And it's less personal that way, and less litigious as well. So founders, and the Facebook is a good example, if they had reverse vesting agreements in place with some of the folks that had been promised stock, and then kind of sat on their claim for a while, but didn't contribute, there would have been no question that they weren't entitled to the stock.
And I have one more person looking for clarification. So they're asking, so the rest of the founders get back those shares. So just maybe explain the difference between that and what actually happens there.
Yeah, so let's say I've been issued 1,000 shares and Chris has been issued 1,000 shares. Again, Chris not pulling his weight. Let's say he met half of the performance targets. And so he said he was going to contribute 50 hours a week to the business. He's only doing 25, and he's going to keep 500 shares because he's met that target, but he's going to lose 500 shares. I don't get those shares, but I still have my 1,000. And so we were 50-50, and now we're 66 and 33. Those 500 shares that he loses just get canceled. They disappear and they go back into treasury. So the relative interest gets realigned, and Chris goes from 1,000 down to 500.
They said that helps. Thank you.
Okay.
So I guess moving on, my favorite discussion, the shareholders agreement.
Should you or shouldn't you?
Yeah, exactly.
Yeah. So it's on the list because oftentimes, if there is money already invested, people are putting in real dollars, they will insist on a shareholder agreement. I prefer absolute victory by way of a shareholder vote instead of a shareholder agreement. So I'm happy to negotiate a shareholder agreement for anybody, happy to write one up. You should know that as founders, you have every right to insist on a shareholder agreement. You will waste a whole bunch of time and a whole bunch of money on legals negotiating one. So unless you're all going to take the form that's provided and sign it without question and without variation, and without seeking independent legal advice, because your corporate lawyer is really acting for the company, not any individual shareholder. And so they should be telling you, look, here's the form, we act for the company, so we can negotiate this. But if you have any questions at all about your own personal interest, you should go see your own lawyer, and then we can negotiate that. And that'll slow everything down, because then you've got other people involved, other people negotiating, and they'll want to make the agreement suit that particular circumstance. So instead of engaging in that whole conversation, I prefer not to have a shareholder agreement right out of the gate. You can have a major shareholder agreement where, let's say you're doing crowdfunding, for example. You don't want everybody who holds 100 shares having a say. So you can have people who have invested a minimum amount, say $100,000, happy to take their calls. Not happy to take calls from people who own $5 worth of stock. It's going to slow down your day considerably when you have probably more important things to do. So you can have a shareholder agreement that's meaningful amongst major shareholders. It's also cumbersome when you need to get anything done, because the shareholders agreement will set out what approvals you need for certain corporate activities, such as a merger or a liquidity event or a sale of all or substantially all of the assets of the business. And then you need to go back and you need to get because it has to be unanimous, every shareholder's signature. Unfortunately, people pass away, people get divorced, people lose their share certificates, people forget that they invested in certain companies, and they move, they're hard to find. And so it's really a pain to go back to everyone and try and track them down in 2 or 3 years to get their agreement on anything. Better to make sure that you gear the shareholdings appropriately. You've issued enough founder stock that you can control the outcome of any corporate event. And if you're bringing on new investors, that the real money, the big money, can enter into some kind of voting agreement with you so that you can determine the outcome of any of those statutorily required shareholder votes. If you're not in a position to do that, or some of your major investors want certainty, there is a cost associated with negotiating and settling the form of shareholders agreement. So I caution you on that. I would rather just either agree to a form, have everybody agree to it, and then throw it in a drawer and not worry about it until you have to. And if that's not easy, then don't do one and take your chances. Make sure that the money you raise is either non-dilutive in a material way, or that the partners you're bringing on enter into some kind of voting agreement or major shareholder agreement where you can control the outcome of a shareholder vote.
So Chris, do you have a specific number of founders that are setting up a company that you think a shareholder agreement should be in place with? If it's 2 or 3, or at what's that threshold where you think you need to activate the shareholder agreement or have that in place?
If you're looking at more than 5, that starts to become an unwieldy number, and the politics that get played amongst the founders group, again, especially if they're not a tight-knit group. So if you're bringing a team together that doesn't know each other well, hasn't worked together before, then you may prefer the certainty of having a shareholders agreement in place. But really, when you're starting out, do you need it? Is it going to slow you down too much? Probably, just from a business perspective.
I've seen it both ways, where it brings some predictability and stability to the company, but obviously as a founder, you lose control of almost everything. So you really need to consider that. So we do have a question on this. What if you have a USA before you have these partners? Can they sign on to the existing?
Absolutely. So your USA will require any new shareholder that's coming on to become party to that USA. So if the agreement's written correctly, it will have that clause in it, and they will have to become parties to the agreement. They won't have a choice. So if they want to become involved, and your option plan, which is our next topic, should have a clause in it that says all shares issuable on exercise of options, if there is a USA, will be subject to the USA. And all of your stock should be legended to alert any potential purchaser to the fact that there is a shareholder agreement that's in place.
And I have another question here, Chris. So do the majority of shares win, or can you establish a 60, 75% or other threshold for certain votes?
It depends on the question. And so the Alberta Business Corporations Act, the Canada Business Corporations Act, and most shareholder agreements will require a special majority in some cases. So for example, on the sale of all or substantially all of the assets of a company, it's 2/3 under all 3 of those examples. For the election of directors, it's a simple majority, so 50% plus 1. So it depends on the circumstance. Your shareholder agreement, if you are going to do one, will set out, again, if it's written correctly, those circumstances that require a special majority. And you can fix a higher threshold than the statutory minimum if you want. So I have seen some shareholder agreements that require 75% majority for certain questions, as opposed to just the statutorily required 66 2/3.
So another question here. I'm looking for an IP agreement to manage IP with a university. Can I get a copy of this agreement somewhere free of cost?
Sure, Google it. You get what you pay for. Is the simple answer. Most universities will have their own form of agreement. So if you're looking to save costs, that's your best start. But know that the university giving you the form of agreement that they like is heavily weighted in their favor and may not actually suit your needs. So the best way to proceed on that basis is to ask someone, do you have a form that you like to work with? Take that form, have a read yourself, and then engage counsel to review the agreement. Universities also, depending on which arm of the university you're dealing with, will often be able to negotiate those forms of agreement. There are certain aspects that different universities, depending on their business acumen, will insist on, and certain others where they're quite flexible and open to negotiation. So that would be my counsel.
There are some tech transfer programs, so it depends on the university you're working with. If you want to send me a private message there are some programs, but I don't think they're free of cost either, to be honest. I think if you want to protect yourself properly, you're going to have to pay a little bit to make sure you're doing it right, would be my recommendation. So if you let me know what school you're working with, I can help on that end.
And just before I take the next question, I guess a comment for myself too, that, nobody wants to talk to a lawyer. They see a lawyer, they see dollar signs. So, with Google and everything, it's very easy. Like you said, you get what you paid for. So, I think one of the things I've learned, and I think the transition that's happening with a lot of law firms, and I can speak specifically to Fasken in how innovative and creative we're getting for startups and understanding the costs you have. But I've got a group of 25 different people that I can access. And you know what? We'll get on the phone for 45 minutes or an hour. We're not going to charge you. We're going to understand where your challenges are, your pinch points, and just give you some real advice. Not, like I said, you're not going to get billed for this. But I think the more you educate yourself and have those conversations with, like Chris mentioned, talk to 3 or 4 different lawyers or 2 or 3 different people, get that knowledge from them directly, the expertise, because this is fundamental to the future and the success of your business. It can affect so many things in the future. And I was always looking for the cheapest legal costs I could find. But again, going through, like Chris mentioned as well, it's about the relationship. It's, sitting down with Chris or others on the team, whether it's at Fasken or whatnot, and really getting an understanding of how they approach startups, how do they structure their fees. We've gotten very creative on how we're doing that, because we understand this is a big cost for you. But I have to say and agree with Chris that you get what you paid for. So yes, there's some opportunities with, as Dana mentioned, some different templates and standard forms. But I highly recommend just chatting for an hour with some lawyers and getting an understanding.
So good answer. I think the bigger question is, when you go to seek investment and outside investors through their due diligence will see a copy of the agreement that you come up with. If you've got a Google Doc or free agreements that you found online, that's an indication of your level of sophistication. And this is going to sound harsh, but reputationally, you will do yourself more harm by pulling something for free that isn't kind of well accepted. Than you will by, again, spending a little bit of money to make sure that whether it's the university's agreement or an agreement that counsel has probably reviewed 1,000 times before and is very comfortable with. So there are ways to find efficiency on cost. There are, like I said, do you need a shareholder agreement? No, you don't. But on a technology transfer agreement, you want to spend the time and money to make sure that that's right? Absolutely you do. So you need to pick and choose where you invest your own money and your own time.
So just being aware, we've got about 20, 22, 23 minutes left. So Chris, another question here. If you have no USA, just the default AB registry agreement, business with 2 partners who are 50-50, what is the best way or option to orchestrate an exit?
You need to sell the company. That's the practical answer. This happens a lot. You can either enter into some other kind of agreement where one partner is buying the other partner out. You shouldn't ever do 50-50 without some kind of agreement. So if it is just you and a partner, let's say it was Chris and I, and we've each got 1,000 shares, and he's actually pulling his weight for once, and he keeps his 1,000 shares, we need a way out. We need to either sell the assets of the company or we need to sell our shares. That's the easiest and best way out. had a situation, clients were in a dispute. One shareholder came to us and said, is there anything we can do? There were allegations of, some accounting irregularities on the other side. I said, look, find a buyer that at a price level that is going to suit both of you, and get out, because otherwise you're stalemated and there is almost nothing you can do. Can you go to court and have a judge force a buy sell? Yeah, you can. And the only winners there are the lawyers. So better to find either come to agreement with your 50-50 partner, or just sell the company and start again.
So Chris,
sorry, Chris, there is an add-on question to that. So I don't know what the plans are here for the person asking this question, but they say the company could buy shareholder insurance where a shareholder dies and remaining shareholders can cover the cost of purchasing the shares, so key person. But that would be a little bit different, right? That would be if someone passes versus wanting to exit the company. So
yeah, absolutely. And so you're generally, though, you're only going to buy key man insurance because it's required in a shareholder agreement. So if you're being thoughtful enough that you are thinking about insurance, you need to think about who should be covered by that insurance. And so in the 50-50 situation, yeah, absolutely, insurance makes sense. If those shares have value, insurable value, then hopefully one or the other partner has enough cash to be able to buy the other out in any event, as opposed to company, spending money on insurance premiums. But that is a good solution. It would require agreement between the parties, though. And so if you're already doing that, you probably have some kind of shareholder agreement in place.
So Chris, just with the last 4 or 5 different items here, if you want to talk, I think we're on stock option plan.
Yeah. So we've incorporated, we've rolled in some assets, we've issued some cheap stock. Now we need to kind of come up with a compensation plan to incentivize folks to either join the board or join as employees. My favorite tool here is performance warrants. Again, I love performance. I love people contributing and getting rewarded for it, as opposed to the more passive stock option plan option, which is good and good for consultants and directors who aren't active in the day-to-day operations. On the performance warrant side, I love it because you can get people incentivized at a very kind of low strike price. So before you do your seed round financing, almost at the founder stock level, you can issue warrants to people who can exercise them for stock. It's not considered an option, a stock option that would be covered by your stock option plan. It's outside of your plan. So most plans will cover 10% of issued and outstanding stock. And those performance warrants will be taxed differently. So you need to be aware of that, which is why it's important just to do them at the very start. We can't kind of do them on a continual basis. So if you have key hires that you're going to bring on, either a finance person, technical person, lead developer that you really want to bring in, and you want to incentivize those folks with equity, performance warrants are a great option. Stock options, that's more of a rolling plan, and you can issue those at higher and higher valuations as you go. So think about that. Those are fairly standard, but they're important to do right. And so make sure that you're getting reasonable advice on that. Once you've got a number of shareholders, you should be thinking about, just like in your shareholders agreement, if you don't have one, a voting trust agreement. So again, anybody who hasn't invested real money or has a small number of shares, you may want to tie those folks up with a voting trust agreement where they effectively give a proxy to either the CEO or the chairperson to vote their shares, or a share restriction agreement, which restricts somebody's ability to vote their shares and stop them from, thank you for the money, going to cash your check, going to issue you some equity, don't want to hear from you. That's really what we're doing there. The advisory board agreement is really important. Again, because those folks should receive options or maybe even warrants of some kind, you want something from your advisors, either on a technical basis or on a reputational basis. So for example, and we just announced this kind of on social media this morning, I'm chair of a political social network startup called Citizen. We've just brought in a very high profile female as chair of our ambassador program for Canada. And so we want to make sure that she's compensated appropriately and also is bound to, you know, provide the services that we've discussed with her. She's bringing her reputation and her network, and we want to make sure that that relationship is well defined. So you should think about having an agreement for your advisory board, not just agreeing to bring people onto your advisory board. You need to think, because they don't have voting rights, not your board of directors, you want to think what they're contributing and what an appropriate compensation level is, and define that. You need to make sure, especially if you're in the tech space, the intellectual property space, that all of your IP is locked down. So the founders who are contributing IP, any consultants, third-party developers, absolutely have to be locked down. This is a ring fence. Confidentiality agreements, before you even kind of open the kimono and have a real conversation with somebody, before you share your business plan, before you share any code, and or IP assignment agreements that include confidentiality clauses. Absolutely everybody who touches your idea needs to be locked down.
Yeah, I have some experience with that. Not so good. Wasn't involved in the hiring process, and there happened to be a document that was missed.
Yeah. So it can cost you millions of dollars down the road if that ring fence isn't tight.
Yeah.
So make sure that you are dealing with people you trust, and even then you should have agreements in place to make sure that none of that intellectual capital is subject to leakage. So that brings us to the last, which is the 10th, the non-disclosure agreement. So again, as you kind of launch your company, launch your process for engaging with the world and hopefully generating some revenue, your business partners need to be subject to a non-disclosure agreement as well, so that you can have reasonable business conversations with those folks without worrying that they are sharing your ideas and your intellectual capital for free and without generating potential revenue for you.
Yeah. So Chris, we got another question here. Starting a new company, 4 partners would like equal profit share, 25%, but one of the partners should have 51% or more decision-making control. Should this be done as different share classes and a USA, or is there a better structure to consider?
If you are going to allocate different rights in terms of control, that kind of points towards a shareholder agreement, something custom, and maybe different share classes so that you can apportion profits separately or at different times. So there are circumstances where in a smaller business where you're not planning on bringing outside investment, you can design that in concert with your tax advisors to make sure that that's going to work. If you have 4 partners and they're going to get an equal share of the profits, but one of them will have more control, you probably only need 1 class of shares. That'll ensure that all 4 get any dividends on an equal basis, but the shareholder agreement can deal with some of the control issues and special voting rights.
Question here too. Can you recommend a book or resource to revisit these documents and concepts I could bring to my partner?
So no book, no suggested reading. Really, what I did in preparing for this session and pulling together this list was to run through our startup program, which again, standard $2,500 across the board. You get access to all the different forms, and I pulled what I thought were the most important ones for a startup. So all of these agreements are included in our package.
And more.
Well, and more, but
Yeah.
these are kind of the top 10 that I had selected. I can give it some thought though, and we can follow up. So if you want to follow up with Chris or I, we can suggest some reading. I think Chris, the last session we did, you had mentioned a great book for.
Yeah, on the venture capital side.
Yeah.
Dana, what was the book I mentioned? You remember?
It's Venture Deals.
Yes. Yeah. Which is a great book. And, obviously, Google's wonderful. I saw somebody saying, research Google, gather as much knowledge as you can before you talk to a lawyer. I do have to say, though, that, like I said, just my experience of being an entrepreneur startup guy, knowing Chris for almost, I don't know, a decade or more, I guess it's been, since he represented me on my first deal. I mean, my deal would have never got done if I wouldn't have had the advice of Chris and people on his team. So it's just really taking that time to speak to the experts.
Most lawyers will take your call and,
Yeah.
and give you some free advice, because right out of the gate, they're, at least I am curious. I want to know about your project. I find it interesting. I love the startup world because you just get into so many different areas. I've been doing work in the crypto space for over a decade now, and you never know who's going to walk into your office or who's going to give you a call or send you even just connecting on LinkedIn, and what you're going to find. And so I think the first call, don't be shy. So yeah, do your homework, figure out what questions you want to ask. But I think I'll talk to anybody. I talk to you. So don't be shy about calling up a lawyer and just saying, look, can I have a few minutes of your time? I'm interested in your startup program. I've got some questions, and I'm talking to a few lawyers, and so we're in business too. We want clients, and so they should have a conversation with you, engage with you, and you can learn from them just as easily as we can learn from you.
So another, I guess learning from myself is, what are the requirements for record keeping? What, from a minute book perspective, and should you be doing that yourself as a startup, or, I look at what via Fasken can do and how, accessible that is.
So the boring answer is the Act does require you to maintain a minute book. Have a registered and records office. That can be your home, your garage, could be your lawyer's office. I like to keep them because I like to know that my clients are actually up to date in their filings, and that we're incorporating all of the required resolutions to give effect to all of the things we're talking about today. So yes, you're required to keep one. They're old and paper-based for the most part. We are really trying hard to digitize them and allow clients to not be afraid to keep them themselves, but digitally, so that you've got access to them. Because if you go to set up a bank account, the bank will ask for copies of your articles and bylaws, maybe your shareholder register, and for you to have copies of those on your phone, accessed remotely, is critically important. Most firms don't have that kind of program set up. Lawyers are kind of protective of them. I don't think you should be. I think those should be easy for you to access and easy for you to share, just like having your cap table done, set up, and easily accessible. And we do have a digital program for that called via Fasken. So easy, and we're trying to make it easier for entrepreneurs to access those kinds of documents.
Great.
It is important for you to
Chris,
keep it.
I do have another question that was asked in the background here, so I'll ask that and then we'll get to the next 2 or 3. So several fintech groups comment regularly about socializing ideas as widely as possible. How do you balance that with protecting your IP?
Well, you can talk about a concept without getting into the detail. So, in terms of thought leadership and everything else, be at the macro level, be in the opinion sphere. But when it actually comes to developing technology, keep that to yourself. Unless you want to work on an open source project that generates 0 revenue, which doesn't really pay your rent, you should be very protective of your secret sauce. So unless and until you're ready to launch, you should be keeping that to yourself and having that ring fence. There are different perspectives on that. Those are hard. I think those are hard to monetize. It's hard to monetize an idea that you've already shared with the world. Just on the radio on the way in this morning, there was a news story about having open source patent sharing around the COVID vaccine. It's hard for drug companies to give that intellectual property away, because then the incentive to develop that intellectual property disappears. And what you're really talking about is a social good, which has merit in and of itself. And so you can think about that. But if your project is profit-based and the goal is an enterprise that earns revenue, it's hard to do that if you've given all your ideas away.
So great question up here. Do I need to be concerned about confidentiality when interviewing lawyers?
Good question. I consider even the free call to be subject to solicitor-client privilege. And so that's the perspective I take. So the answer in my case is no. All lawyers will owe their clients a duty of confidentiality. I refuse to sign non-disclosure agreements because I don't want to be contractually bound to something less than solicitor-client privilege. I don't want there to be a reason for anyone to doubt that any conversation you have is confidential, and that I can't disclose it unless I'm required by a judge, by a court order to do so. My general answer is no. I think it would be a rare circumstance where you had a conversation with a lawyer for an hour, even though you didn't pay the lawyer a fee, for them to be sharing that idea with anyone. And I certainly think that that would be conduct unbecoming of that lawyer that could be actionable.
That's a large reputational risk, right? Even in our group at the Executive Business Advisors, everything you say to us is confidential from the first time you speak to us, even before you sign the terms of agreement. And it's just a reputational risk. Like if people know that you're working in the tech space and talking about ideas after you've spoken to them, you're not going to go far, right? So just as a rule, I wouldn't be super concerned about that, especially with a lawyer.
And it is, our ecosystem is small.
Yes,
Word will get around pretty quickly. And you know, I love it because it keeps people polite, but there are risks, huge risks, as Dana pointed out.
And for myself, I'm you know, I've got a contract in place with Fasken and with Alberta Innovates, so pretty tight circle around me. So again, it is a great question. I think I agree with your comments 100%. So that was great, Chris. So another question here. This might require a bit more offline discussion, but 10 years back, I worked for a company developed one of my technology ideas. I was an employee. My role was not to provide the kind of support. It was outside of my roles and responsibilities. Can the company own it without compensating me?
Yep. Because if you're an employee, then everything you do in your employment is owned by the company, generally speaking. There are exceptions to that. So even if you did it in the context of your employment, or you contributed to the advancement of any of that company's intellectual property, if you were an employee, generally speaking, you know, it's owned by the company.
Some great comments just saying, you know, appreciate the time getting our house in order. Yeah, again, it's as an entrepreneur startup, you got lots of different things, moving pieces, but spend the time on putting the proper structure. And as Chris mentioned, and we're happy to myself take a call for an hour and just learn about what you're doing and where some of your challenges are. So Dana's posted my contact info there. So please reach out. Happy to do you know, a consultation call for free and involve Chris and some of the others on the emerging tech group as well.
So you're right, Chris. Spend some time on these things, but don't fret about it.
Yeah.
Don't let it take your time or attention or money away from other things. So do be businesslike about it. interview who you need to interview, find the right package for you, but don't spend too much time and don't spend too much money on it. It is a cheap insurance policy against some of the problems that can develop even months after you launch, but usually years. And then you look back and with hindsight think, geez, I should have had an NDA with that person. I should have had a shareholder agreement. You're never going to know what you should have had 10 years down the road, but for low cost and low time investment, you can get a fair ways down the path to making sure that some of those problems don't arise.
So a couple minutes left, closing comments.
I think that was it.
Yeah.
Don't spend too much time, don't spend too much money, but please do be pragmatic, be efficient, and use this as a cheap insurance policy against some of those problems. And also, by using some of these agreements, you will demonstrate to outside investors that you know and care enough about your structure to make sure that all of the things that you need and that that investor will be looking for on a due diligence basis are already in place. And that goes a long way to facilitating additional investment down the road.
Yeah,
So
we
Dana,
often tell our clients spend the money now to avoid spending way more later, right? Like it doesn't have to be crazy. There are a number of these organizations that have the startup costs set up like Fasken does. And there is the free advice from working with Chris and the team initially, right? So just spending a little bit of money to avoid looking back and saying, oh shoot, I really should have done that is a good idea. And so I wanted to say thank you to both of you. This was a great session, lots of fantastic information. And thank you to all the attendees for all of your great questions. We appreciate you interacting with us so much. And we will have a recording of this session, so we will share it with everybody that came. And then if you have any questions or want to get in touch with Chris, his information is there. And then if you have questions about the Executive Business Advisor program, my information is there as well.
Fantastic. Thank you so much, Dana. Thank you, Chris.
Thanks.
Fantastic.
Thanks, everyone.
Thank you both. Okay. Have a great day, everyone.